We are.
This is a planning board public hearing. And the planning board meeting and public hearing are broadcast live and digitally recorded. Of course, I'm wrong. It's a planning board meeting inside which there is a public hearing. So the meeting can come to order, and then I believe I need a motion to enter the public hearing. Is that true?
I'll make that motion.
Thank you.
I'll second it.
All in favor? So now we're in a public hearing. I'll read this notice of public hearing. Pursuant to provisions of Massachusetts General Law, Part 1, Title 7, Chapter 40A, Section 5 of the Town of Hubbardston Planning Board. Section 5, the Town of Hubbardston Planning Board will hold a public hearing today, 6:30, in the town office. Did I do the digital notice?
I'm sorry,
Did I do the digital notice
do the digital notice of what?
of the meeting? Planning board meeting
Yes,
is
you
a
did,
public
you already,
hearing?
yeah,
Okay.
that it was broadcast live and digitally recorded.
And we're on, so I'll keep reading. 6:30 in the town office, Slade Building, today here. Discuss the proposed change of a zoning bylaw, Article 7, Special Permits, Section 7.6, Associate Member. The proposed change would modify the current text of the first sentence from, and now I'm gonna deviate from the public notice and read directly from the latest edition of the town warrant. There's one word change, but nevertheless, I'm going to do that.
You all have that in your packets, just so you know. We're looking at Article 27.
I'll read the whole article. To see if the town will vote to amend the Hubbardston zoning bylaw, Article 7, Special Permits, Section 7.6 as follows. First sentence, delete recommended and insert appointed. Delete and appointed by the select board, insert, quote, from the residents of the town per Massachusetts General Law 40A, Section 9, unquote, such that the sentence as amended will read 7.6, associate member. There shall be one associate member appointed by the planning board from among the residents of the town per Massachusetts General Law, Chapter 40A, Section 9. A 2/3 vote is required. This was submitted by myself, and I see that the Board of Selectmen don't recommend it, and the Finance Committee does recommend it.
Tom, I'd like to make a motion that we entertain the vote to ask you to recuse yourself, since this is your motion or article to go through in front of the town. And,
I don't see a need to recuse myself.
well, I'm making that motion,
Well, you can make the motion, but
okay?
I don't have a plan to recuse myself. There's.
I
go ahead,
believe
Alice.
it's right here in the law, sir.
No,
I think
don't
the
it
question,
is in the law.
the question
Go ahead,
has
Alice.
come up whether you're an interested party in this item before the planning board, which is in chapter, 41,
Well,
section 81A.
Let's
I don't
just
think you'd
step
have to
back.
recuse yourself, but I'm not sure it'd be proper to chair the meeting, because that gives the impression that it's this board that has presented the
No,
change.
it's clear that the
And
board
it's
has not
not, it's
presented it.
an individual that's presented it, and I think that's,
No, I just read the article, and it clearly states submitted by Tom Robinson, Hubbardston elected official. That's what it says right in the article.
right, but
That's not
we
the
need,
planning board.
we need to make it, but can you both chair the meeting that's discussing it and present why you want to have the change? There's where I think the conflicts comes in, so it'd be better if somebody chaired the hearing, I think.
I don't believe there's any conflict. The conflict normally arises when there is a third party. And here there is no third party. This is planning board business. It's administrative. There's no benefit flowing to a landowner or a business owner. There's nothing like that involved. So I don't see any conflict at all. In fact, I consider this my job as an elected official to bring forth bylaw changes.
But I think if you wanted a plan, if you wanted us behind us, it should have been presented to the board so we could present it to the public as a recommendation of the planning board.
Which is not.
I'm sorry?
If you wanted to present a bylaw change on behalf of the planning board, as opposed to as an individual, you should have come to the planning board first and had our endorsement as the planning board to put this article on the warrant.
Every bylaw change has to come to the planning board. By
Correct.
law. And that's what
Correct.
we're doing tonight. And you have your choice to either endorse it or not endorse it.
But you're still chairing the meeting when
That's
you're
my
the
position.
individual presenting it and it's not a planning board.
Well,
Not being, it wasn't placed on the warrant through the planning board.
let me say that, let's start off with a very simple comment. We received some board notes, they call them board notes, in the agenda that was handed out
Yes.
here just a couple days ago. I suggest that members of the planning board put those notes aside. They are not legal interpretation. Neither our clerk nor the town clerk are lawyers with responsibility to interpret the law. We, as elected people on this board, are responsible for interpreting the law. So,
But there is a motion, and I think some of us are concerned about the apparent, what appears to me to be kind of a conflict here.
well, is there a conflict or not?
I think it is, if you're presenting to the planning board, major change to zoning bylaw, and you're also running the discussion and voting on it.
I'm not
I'm-
running the discussion. We're here tonight for the sole purpose of obtaining testimony from the public. And I'd like to get on with that.
So you don't intend to make any presentation
Yes,
to
I
the
do.
board? Well, then, that's the issue, I think.
I can step to the other side of the table and make a presentation.
Well, I think you should do that and then let
Well,
somebody else chair
I
the
haven't started my
meeting.
presentation yet.
Okay,
So I'd like to hear testimony from the public regarding this article. We read it in its entirety, in its latest
you had a motion on the table.
edition.
Yes, I do. We're not going by proper procedure, that's
Well,
all.
what is the motion?
The motion was on the floor, Tom, that I wanted to make a motion to ask you to step aside as chairman as you were presenting the article to the board and let somebody else run the meeting tonight. And we haven't done anything with that yet.
I'm not presenting this article in any manner other than every article gets presented to the planning board. Every bylaw change has to, by law.
So
be
the rules they have in
presented.
this law here, we don't have to go by.
I suggest you put these interpretations of the law aside. Our clerk and our town clerk are not our legal interpreters of the law. We are, in the first instance, and if we have questions, we go to KP Law. No offense meant, but
No,
that's not how we resolve legal questions. We don't ask the town clerk.
I don't think it's just the town clerk, though. I think there is an apparent conflict of interest here. You've got somebody presenting a change to the zoning board for consideration as an individual that's not on the boards. Yeah, I don't know, I do think there is a conflict of interest to be both the presenter and the chairman of the meeting.
Well, if you wanna read the law, no member of a planning board shall represent before such board any party of interest in any matter pending before it.
Yeah,
These are, I read that as third party. If Ed Blanchard had a, interest in land and I was speaking on his behalf as a member of the planning board, that would be a conflict. That's an ethical conflict and a legal conflict. This is an administrative issue. It's a planning board issue. As chairman of the planning board, I had the right, under our charter, to present the selectmen for the article on the warrant. I've done so. They read it, accept it, and send it back to the planning board as they would any article. All articles are treated the same. all bylaw change articles are treated the same. That's what I'm doing.
I don't think the process of our deliberating on this is different. I think what's different is that this was not, that this was presented by somebody who sits on this board. As
Well,
opposed
even-
to a change
even-
that the board voted on to then be considered by the select board.
Even the interpretation that I'm asking you to put aside doesn't say I should recuse myself.
I don't think you need to recuse yourself and exit the meeting. I just think you shouldn't be representing the planning board and representing your article at the same.
Well, would you like to take over as chair?
I would like to chair this meeting, or I'd be willing to.
Then go ahead.
Okay,
So I make a motion to do that. How's that?
all right, so your motion is to
Ask Tom to recuse, to run the
Yeah.
meeting as chair and allow,
not to recuse himself, but to
not from the meeting.
remove
no.
himself from
Chair.
chairing the
Right.
meeting.
Because I think it's a conflict too, Tom.
Well, I don't, but we disagree, and I think we resolved. If
Okay.
you'd like to proceed,
Thank
fine
you,
with
Tom.
me.
Okay,
I think you have a motion.
Point
but
of
you
order,
gotta
yeah,
have a
we
Oh,
second.
yeah, we have to
Second.
vote on that now. So who,
Second.
we have a
okay.
second, Craig?
Any discussion? All in favor?
Aye.
Not me.
So it's three, did you vote for it? Okay, well, I just think
So
it's the
it's,
right
the
thing to
vote-
do.
the vote is- The vote is,
I am not voting on this.
So he's abstaining, okay.
I'm abstaining.
Okay. So, again, to our public, the hearing's called pursuant to Massachusetts 40A Section 5. It's a proposed zoning bylaw change that was submitted by Tom Robinson, acting individually as a town official, as opposed to proposing this bylaw amendment on behalf of the planning board. So his
Town official
authority
or a
to
town
do
citizen?
that, what please?
As a town official or a town
As a
citizen?
town official, and his authority comes from the town charter, namely 233, which states that the Board of Selectmen shall include in the warrant all articles submitted to it by an elected town officer. Okay, so just to clarify that for the public. So the proposed amendment changes the zoning bylaw Article 7 regarding special permits, the provision regarding associate members. So the proposed change would modify the current text of the first sentence from, "There shall be one associate member recommended by the planning board and appointed by the select board," to, "There shall be one associate member designated by the planning board from among the residents of the town," per Massachusetts General Laws 40A, Section 9. And submitted with that was a second warrant article, which is not before us because it was an amendment to the town general bylaws, which would remove from the select board list of appointments they can make, the power to appoint the alternate member. So, does that make sense to people out there?
point
So
of
we
order.
can't vote on the general law tonight because that's not within our purview. What the planning board has to do is make a recommendation on the change to the zoning bylaw. Point of order, go ahead, Tom?
No, I was just going to say the article regarding the general bylaws is not the purview of this meeting.
Right,
or
which is
this-
what I
this
just
hearing.
said.
That's
Okay,
why I,
but in order to
stopped.
understand it and to eliminate the conflict, you're gonna see two articles on the warrant. One of which gives the appointing authority exclusively to the select board and removes that authority from exclusively to the planning board and removes that power from the select board. The way it presently reads is the planning board is supposed to recommend a candidate for that position and the select board appoints it. So, if everybody understands that change. And just as a background, the associate member of the planning board exists so that if there's a vacancy, absence, conflict of interest in the planning board, in the case of a special permit, the associate member can fill in and vote because it requires a 2/3 vote, and otherwise you couldn't get there if you had a conflict or absence on a 5-person board. So, notices of this hearing has been given to the towns, MRPC, DHCD, and it has come to the planning board from a referral from the select board, which is the procedure set out in Massachusetts General Laws, Chapter A, Section 5. And the select board has voted to not recommend the article. So that's where we are today. So, I think the procedure would be to let Tom Robinson, who's the petitioner, explain his, why he proposed this warrant article and the benefits that he sees from it, and then to allow other people in favor or against the article to speak. Then we can close the public comment period, but it'll remain an open meeting. And the board can deliberate on whether we want to recommend or not recommend the article and why to send to the town meeting. So with that, I think I can turn back to Tom and say, would you like to present your thinking on this article?
Should I do that, or should we allow the public?
No, I think you should go first, because you're the person proposing it.
All right. Is it acceptable to the board that I sit here, or do you want me to get up and go over to there?
I'm okay with this.
with you
sitting.
Just checking. You know that last fall, fall and winter, we spent a lot of energy on this issue. And the basic issue is that we want to be in full compliance with the state law, specifically 40A, Section 9, regarding special permits, which says that you can establish a means to appoint a associate member. So this article will bring us into full compliance, unequivocal compliance with 40A Section 9. This article will also establish the planning board's authority, as provided by the voters, to appoint the associate member, independent of the actions of any other elected board. I think it's, I don't know of a case in town government where one elected board reports to another elected board. This isn't like a department in a company where this division reports up to another division. We are independent and elected. And this article, as I said, will establish the planning board's authority, as provided directly by the voters, to appoint the associate member, independent of the actions of any other elected board. And indeed, that is the way the town's organization chart reflects the relationship between the planning board and other elected boards. There is no interconnecting lines. We should be held accountable by the voters and not influenced by other elected boards. Or we can be influenced, but not directly impacted. This also assures that the associate member is appointed from among the residents of the town. If you'll note, the general bylaws, page 4, talks about elected officers, and to be elected, I believe you have to be a resident of the town. It also talks about officers to be appointed by the Board of Selectmen from among the residents of the town. And it lists Agricultural Commission, Board of Appeals, Board of Registrars, Capital Improvement Planning, Conservation Commission, Council on Aging, Cultural Council, Historic Commission, Historic Resources, Advisory Board, Montezuma Regional Technical School Committee representative. All of these, appointed by the Select Board, are from among the residents of the town. There's then a third category on this same page, officers to be appointed by the Board of Selectmen. And it lists things like animal inspector and veterans agent, and, excuse me, fire chief and town administrator. Those obviously do not need to be selected from among the residents of the town. We are today using the animal officer from Gardner, and I think that's a good thing. But when it comes down the list a little farther, it says planning board associate member of per town zoning law 7.6. That means that they could select the planning board associate member from out of town. And I don't think that's a good thing. I think it should carry the phrase from among the residents of the town. So that phrase from among the residents of the town was picked off the general bylaw and placed right into the proposed amendment. So, in summary, full compliance with state law establishes the board's authority to govern its own destiny and be responsible to the voters, and ensures the associate member is from among the residents of the town. And that's what it attempts to accomplish. I should say that's what it accomplishes, not attempts to accomplish, in my opinion. So that's my small presentation. If there are questions, I reserve the right to speak to the questions. Otherwise, I'll pass the baton back to you, and you can
Okay, thank you.
conduct the rest of the meeting. Thank you. Thanks for the opportunity.
So are there other people that wish to speak? Should we, either in favor or against the proposed change? Ed Blanchard, you wanna state your name and speak clearly so the camera can see you?
Ed Blanchard, 23 East Comet Pond Road. I think it's important that we know the background, the history behind Article 28 and 29 that's on the town warrant. And I think I was at most all of the meetings where a difficulty took place with the associate member. So I will read this and then submit it into the hearing minutes. Back in 2018, an opening for the associate member of the planning board became available. Anyone interested could apply to the Board of Selectmen's office. 2 candidates applied for the position. The planning board reviewed the applicants and voted 3 votes for Scott LeBlanc and 2 for Francois Steiger. Both candidates were invited to a combined meeting of the select board and the planning board. After interviewing both candidates, the selectmen appointed Francois Steiger. The reason given not to appoint Scott LeBlanc was that he had just lost the planning board election, and the selectmen felt that someone new to the board was appropriate. The chairman of the planning board at the time, Tom Bradco, resigned, and Tom Robinson, as vice chair, took over as chairman of the planning board. Mr. Robinson then refused to seat Mr. Steiger as the associate member to the board. He stated that he had the right to not seat the associate member. Other members of the planning board asked to vote on whether to seat the associate at a regular planning board meeting. Mr. Robinson would not allow such a motion to be made. The stalemate went on for 3 months until it was determined that sending the case to town council would get a legal opinion on the bylaw. Mr. Robinson drafted the letter to the town council on behalf of the planning board. In that letter to town council, Mr. Robinson stated his personal opinion and not those of the planning board. The other members of the planning board did not have an opportunity to see the letter until after it was sent. Some members of the planning board said that it did not represent what the board had discussed at their meeting. A month later, town council ruled that the planning board had the right to recommend an associate to the selectmen, but that appointment was to be made by the select board. At the next planning board meeting, Chairman Tom Robinson did not seat the new associate until members of the board asked that Mr. Steiger be recognized as the associate. During that 4-month period with no associate member, any special permit that required a supermajority vote would have been at risk. The opinion from town legal council costs the taxpayer $612, according to the town administrator. Articles 28 and 29 are not submitted by the planning board, they are submitted by Mr. Robinson as a town official. As an individual, you or I would have to get 30 signatures to place an article on the town warrant, but as a town official, Mr. Robinson can place that article on the warrant. The reason behind having the select board appoint people to boards and committees is one of checks and balances. Allowing a board to place its own associate member allows for the boards to stack a board with friends or those who think like the rest of the board. The select board has appointed associate members to the planning board in this way for decades with no problems, and we should leave our bylaws as they stand today. Before this hearing is over, I would hope to hear from the full planning board as to their recommendations regarding these articles. Thank you for listening. Respectfully, Ed Blanchard, 23 East Comet Pond Road, Hubbardston, Mass. Thank you
Thank
for
you.
allowing me to speak.
Do you wanna submit? Oh, you take to the clerk, you pass it down.
Welcome.
Christina, thank you. Does anybody else wish to be heard on either side of this matter?
I just have a question.
Yes?
Um,
You gotta state your name.
Deb Reed, 16th Street Road, Mass General Law 40A, Section 9, the sentence says, "The chairman of the planning board may designate an associate member to sit on the board." That, I believe, is really the crux of the matter here, is putting our laws in line with Mass General laws.
But we also have if I can just address that for a minute, the general bylaws give the power to appoint, so it's,
I understand,
right, so there really is a conflict which the town council addressed,
I understand.
between, as long as you understand.
Yes, because one
Okay.
says our laws right now say recommend, they do not say appoint.
Right,
So my
this would,
question here is, you've got, from the Mass General laws and from your meeting, notice, the words say exactly what the law says, designate by the planning board.
No.
And,
In its final form, as I read tonight from the actual warrant, the word is appointed. Appoint, not designate.
and
it has been
very-
amended, Tom?
Pardon me?
It was amended?
Yes, it
by
was
you?
amended by KP Law.
Okay. Does that answer your
That was my
question?
as what the words got changed from meeting notice to the warrant, and I was just,
Yeah.
my question was why they got changed.
You had to
I didn't
pay
get
careful
this.
attention to my reading, and I'm sorry I didn't point that out.
We do have a copy of, the article,
I have
the
it.
warrant here?
I have
Yes.
it. Thank you.
So is it correct on the warrant here, or were you reading
The
from
warrant is the correct wording, it's what I read earlier today.
Right, it's changed, the wording
Okay.
is changed from the meeting notice to the warrant, and that was my question. But Tom just said.
I think it was picked,
KP law.
Christina can correct me if I'm wrong, but I think that was picked up by town council after the meeting was posted
It was.
and the recommendation made, okay? Thank you.
So what is the change? I'm not clear.
The word designated is changed to appointed. What are you reading?
I'm reading the planning board agenda public hearing.
Would you like a agenda, or would you like I'm sorry, a copy of the warrant? Christina has a separate one. You wanna circle the provision for him?
It is right here. There you are, that was downloaded off the internet today.
So it's deleted, recommended, insert appointed.
No, deleted designated.
Right,
And
insert appoint.
insert
So
appointed.
the power of appointment would reside exclusively in the planning board
That's correct.
if this passes, and the other warrant article that's paired with it has to pass as well, which removes that power from the select board. Okay, are there other people that wish to speak? Yes.
I do support this change.
Can you state your name?
Mary Robinson, 5 Brigham Street, and I do support this change. The law says that the planning board shall choose the associate member.
Yes, shall the present law, doesn't say choose, does it?
It says may.
It says may.
Shall designate, that's where the word designate came from, I please,
That's weird to have this
Right.
in place.
Well, this would determine the procedure where there was some confusion between the select board appointing or the planning board being able to choose their member. This would clarify that, and I do support it.
okay.
It was a, unnecessary expense to go to the lawyers. In the past, the selectmen have approved the planning board's associate choice, and in this case, they did not.
Correct. The word, I think, Mr. Blanchard's summary was pretty accurate about what transpired.
I disagree.
Okay, we'll let you respond. But the word that's being deleted was recommend, and the word being inserted is appoint.
Right.
So there's no confusion on that. Okay, before you respond, anybody else wanna speak to the board on this?
I would.
Francois, you wanna? Francois
Counselor
Steiger is the present associate member of the planning board, so you can introduce yourself and.
I'm Francois Steiger. I'm the associate member of this planning board, and so appointed by the select board last year. First of all, I would like to thank the planning board. I do have a statement which I would like to read, and which I will then also submit for the records, and give that to a copy to your secretary at the end, if that's okay.
Yes.
Thank you. First of all, I would like to thank the planning board members sitting and listening at this evening's hearing for granting me and my fellow citizens of this town a voice in opposition to articles under consideration at this evening's hearing. The proposed articles submitted by Mr. Robinson to change the Hubbardston bylaws are the result of a 2018 challenge to his and the prior planning board chairman's interpretation of Mass General Law, the town of Hubbardston's charter and bylaws regarding my appointment to the position of the associate member of the Hubbardston Planning Board. A narrow but erroneous interpretation by Mr. Robinson of Mass General Law, the town charter, and the town bylaws created an unprecedented impasse for the town's planning board members. And due to his steadfast opposition to address the situation and disallowing any progress to take place to resolve the matter of my appointment to the planning board. I remind you that Mr. Robinson was forced by the other members of this planning board to request town council's advice finally on this matter. And however, that as was stated earlier, Mr. Robinson took it upon himself to write a one-sided opinion letter also on this matter to the attorney overseeing the matter of the appointment, and mischaracterized said opinion letter as representing the voice of the town's planning board. The articles being presented at this hearing by Mr. Robinson and his past actions on the matter go to the heart of why the articles must be opposed. First, the bylaws have been in place and have been effective to this town for many years, including in 2018, when for the very first time in memory, the select board decided that the not unanimous associate member recommendation presented by the then planning board members was not a well-guided recommendation. Other than in 2018, past associate members, as has been stated earlier, past associate member recommendations from the planning board had always been approved by the select board, and this resulted in the appointment of the recommended candidates. History clearly demonstrates that there is no inherent malintent behavior by the select board of not appointing the candidate recommended by the planning board. Second, I'm sure that we are all very well versed on the checks and balances, which, by the way, does not only apply to federal government, but also applies to state and municipal entities. In essence, it provides a counterbalancing influence by which an organization or systems are regulated, and typically those ensuring that political power is not concentrated in the hands of individuals or groups especially when it comes to special interests. The articles Mr. Robinson has proposed go fundamentally against these checks and balances that were put in place some time ago by the wise individuals who drafted the town's charter and bylaws, and I therefore question the intention of Mr. Robinson's action by proposing that these articles be removed and that the protection be eliminated. Third, these articles are being presented into the town warrant in a legal, albeit a very unusual manner by Mr. Robinson. A fully transparent route would have been to use the body he chairs in order to address modifications by the bylaw in question, or alternatively to submit the articles by means of a citizen's petition, which requires a modicum of 10 Hubbardston residents to include articles in the town warrant. Instead, Mr. Robinson has used the least transparent way to submit these articles into the warrant, and namely the privilege of being an elected town official to submit these articles. Is it legal? Yes, it is. But again, I question Mr. Robinson's intentions in using the least transparent way to put these articles into this warrant. Mass General Law Title VII, Chapter 48, Section 5 states that the Board of Selectmen or City Council shall within 14 days of receipt of such zoning ordinances and bylaws submitted to the Planning Board for review. And I accentuate that last part. I respectfully raise my objection to the process used by Mr. Robinson, the acting chair of the Hubbardston Planning Board, who himself initiated the scheduling of this hearing and bypassed the required prior review of the articles being presented to this hearing by the Planning Board body as required by Mass General Law, Title VII, Chapter 48, Section 5. Mr. Robinson is not allowed to pick and choose sections of the law that are convenient in the process for submitting articles into a town warrant. In my opinion, this is a procedural defect which violates Mass General Law, rendering the process defective, and should invalidate the articles for submission to the town meeting as it is to be held, which is to be held on June 4th, 2019. I respectfully recommend that the members of this board to not recommend the articles presented in this hearing, and also to caution the town administrator and the select board as to the defect in the procedures used by Mr. Robinson in submitting these articles for the town warrant, a process he himself managed and is himself responsible for failing to follow the process established by law. I respectfully submit this here today, May 14th, 2019.
Thank you.
Can I see that for a second?
Forgotten his name. Would you like to speak as
Chris.
well
Chris?
to this article? Chris?
No comment.
Okay,
That means you don't wanna speak?
you don't wanna speak.
That's what that means.
Best, okay. So I'm going to let Mr. Robinson reply to some of the points made, if you'd like.
Yes. I think the history, while unavoidable, I'm speaking to Ed's discussion. Ed led with, we really need to understand the history. I think the history is, while you can't ignore it, shouldn't govern all future actions. If you don't learn from what's gone on in the past, you're bound to repeat them. And so you can forge a new direction as you move forward. And that's what I'm suggesting. The fact that the votes get called into question, or the fact that a candidate lost an election and therefore is ineligible to serve in a volunteer capacity in this town, I think is horrifying. I think someone who loses an election does not lose his rights, does not lose his right to participate. And I think if you look upon a person who has lost an election as in some way, because of the loss of the election, they become disqualified, I think that's a terrible approach. You said you need 30 signatures if you're a citizen. You don't, I believe you need 10. And I'd like to read the whole 2.33. This addresses whether this process was transparent or not. I'd like to describe the process a little bit. Article 2, Legislative Branch, Section 3, Warrants and Town Meeting. I'm on page 3 of the Town Charter. 2-3-3. The Board of Selectmen shall include in the warrant all articles submitted to it by 1. An elected town officer. 2. Multi-member body acting by the majority vote of his members. Or 3. 10 votes of an annual town meeting. 10 voters for an annual town meeting, and 100 voters for a special town meeting. If an article is petitioned as set forth in this section and received after the warrant for the next town meeting has been closed, the article shall appear on the warrant for the next town meeting for which it qualifies as inclusion. This is the town charter. The process was followed. As an elected town officer, I submitted it to the selectmen in a public meeting that was televised right here in this room. Was nothing about it that was lacking transparency. It was all done in public, and I'm offended by the concept that someone thinks I'm doing something behind the curtain. That's not the case. I'm doing this for the benefit of the planning board and for the benefit of the town. We'll let the town meeting speak to it and let the voters speak. I'll take the decision that they make. Mr. Steiger, you also have to be recognized as a person who's running against me in a planning board race to be decided in the next election. I think some of the things you said were pretty offensive.
There.
There's one more thing I'd like to do. I received a letter from a citizen, and I'd like to read it. This is from Vince Ritchie, 1 Ed Clark Road, Hubbardston, Mass. Dated today to the Town of Hubbardston Planning Board. Please accept this letter as my testimony in support of the proposed change to the Hubbardston zoning bylaws, Article 7, Section 7.6, Associate Member. As provided by Massachusetts General Law, Chapter 40A, Section 9, Special Permits, the town voted the current bylaw wording. The planning board at that time felt that the wording of the current bylaw would allow the elected officials of the planning board to choose the associate member by nominating that choice to the selectmen, who would then confirm the selection by appointing that nominee as associate member, a process that would be consistent with Massachusetts General Law and honor the positions of both elected bodies. This procedure worked for several terms in the past and has resulted in many capable residents being chosen and appointed as the associate member. In my opinion, this one elected body should not, it is my opinion that one elected body should not impose its will or power over another elected body. While the Town of Hubbardston Charter gives the power of appointment to the Select Board, I do not believe it was intended to overrule other elected committees. If the Select Board does not respect and support the wishes of another elected body, then they are disrespecting and ignoring the will and the mandate of the residents who voted for the other elected committee, whether it be the Planning Board, or the Board of Health, or the Finance Committee. When a situation like this occurs, I believe it is appropriate and necessary to change the terms of either the charter or the bylaws to correct it and ensure such a misunderstanding does not occur again. I therefore support and endorse the proposed zoning bylaw change. Respectively, Vincent K. Ritchie. Submit that.
Okay.
And I'd also like to point out that when this whole issue started, there was a select board meeting in June 2018, and I attended it, as did Francois. And Francois came to the meeting expecting to be appointed by the select board that night.
I object
Prior-
to that, by the way.
Pardon me?
I object to that because I did not come in with the expectation.
No, you wrote a letter, and you said, my understanding is that the select board would appoint the associate member that night.
Which is absolutely correct,
That's the first sentence of your letter.
which is absolutely correct, but it
All right,
was
so
not
let
my
me talk, please.
expectation.
Let me
It was not
finish,
my
please.
expectation that
Wait.
I was going to be elected.
Can I finish?
Let him make his point, and I'll let you give a
Thank you,
rebuttal.
yes.
Okay.
You came into that meeting, quote, with the understanding. Now, I don't know who gave you that understanding, but it completely ignores the process that was put forth in the existing bylaw or that will be put forth in the new bylaw. So, by not coming to the planning board at all, by not putting an application to the planning board, by not addressing the planning board and expressing yourself, I would propose that that is the lack of transparency. That is the complete circumvention of the planning board. And that got you off onto a very wrong foot, and it got the process onto a wrong foot. And that is the root cause of the issue. And that's what needs to be corrected. And I put forth again that the proposed bylaw changes put us in full compliance with the state law, establishes the planning board's authority as provided by the voters to appoint the associate member, independent of the actions of other elected boards, and ensures that the associate member is appointed from among the residents of the town. Thank you.
I'll let Francois respond, and then I just wanna make, maybe I could make this point first, is
Sure.
just a point of clarification, is the general laws do allow a municipality to create this position, to accept this position, which they describe in the general laws, as an associate member of the planning board. And they allow them, the town, to set up a procedure for doing that. Just so you understand, the state doesn't weigh in on either side of this issue. It's up to the town to create a way to, put that person into office. Okay, go ahead.
I
But
think you bring up a
Alice-
very interesting and a very good point. If I may? I
Isn't
was
it,
given-
isn't it true, Alice, that the process begins with the planning board?
Well, Hubbardston has created both a zoning bylaw and a general bylaw.
No, the appointment process begins with the planning board.
I don't think so. I think it says that the position can be created in a method established.
No,
By
but
the
the way
town.
we have established it, the
The way-
candidate
no,
would
right.
come to the planning board.
Right, the way
and
the
that's where-
town,
yes.
my point was that there is no, we're not ignoring an overarching general law that says the way to do it. That's my only point.
The state gives
Understand.
home rule a very strong role.
Correct, okay. Let's let Francois
But
talk and then.
just on that quick issue, I believe that the select board posts the position, and any candidates wishing to apply for the position do so through the select board.
I don't
That's-
believe this position was
That's the first
posted.
part of the process, I
This
believe.
position was not posted.
Excuse me?
This position was not posted at the time Francois showed up at the select board.
I'm talking about the procedure, not what happened in that particular
Right.
process. You said that it starts with the planning board, and I say that it starts with the select board posting
Yes.
that the
That's
position
true.
is available, and any candidate who wishes to apply for it does through the select board, and then they give you the people who have applied for the position.
That's true for Board of Health, any of the boards.
Finance committee.
And I don't know of an instance when the board recommendation was not approved by the select board, except for this one, in 20 years of looking.
Francois.
Thank you. First of all, I agree with that. I did come to the select board and presented myself as a candidate because the select board had generally opened up the position and had indicated that interested parties should be submitting this here. I was very transparent in coming to the planning board and submitting my request to be a nomination. So what you have indicated earlier is absolutely not correct. There is a letter that I submitted, and that was not only read here, but it was voted on. So the indication that I did not ever present myself to the planning board is totally inaccurate in the manner that Mr. Robinson is presenting this. I will indicate also that the lack of transparency that I'm presenting here is that in a manner that the planning board as an entity ought to function, any changes to the bylaws would entitle the courtesy of the colleagues to have this review taking place within this body. And as a chairman, with that power to be able to present that to this board. Not having done that and instead gone directly into a hearing and presenting it that way, albeit legal, that's the point of lack of transparency. My point is that by not even having a review beforehand by the planning board in general, there is even less transparency to this, except for the fact that there are individuals that are concerned here in town with regards to the impact that this would have, that are actually bringing this up as part of this hearing. I believe that at this point in time, it is up to the board to realize that the process itself that has been followed is not the one that should have been followed because of the fact that the review itself did not take place, which is a requirement under the law. And this is why I say very clearly that Mr. Robinson cannot just pick and choose what it is that, from a procedural perspective, you can select out of the law in order to follow the process of how do you amend a bylaw. And I'm bringing this here to the attention of the board because I do believe that at this point in time, there is a defect in the way that these articles have been presented. And they have not been, it has not been done so by accident, because the person who has presented this here is not just a common citizen, but is a town elected official, and is, by the way, the chairman of this board, and should have followed the protocols and procedures according to what the laws very clearly state.
Okay.
Can I respond?
I just for a point of clarification from him, your argument's coming out of Mass General Laws 40A Section 5, the line that says, in the first paragraph, just so I understand your complaint, the Board of Selectmen or City Council, within 14 days of receipt of such zoning ordinance or bylaw, shall submit it to the planning board for review.
That is correct.
And then the planning board must hold a hearing.
That is
You're saying
correct.
that review process, that review was
Didn't you
skipped.
send it to everyone?
Correct.
Okay,
Once
just so I understand, and that's outlined in your submission, right? Correct?
It is.
Pardon me?
Okay.
I didn't hear the question.
I just asked him whether his argument was also outlined in his submission.
Yes, it is.
Okay. So,
Can I respond to it?
we just need to understand, and you may respond to it, yes.
The Board of Selectmen shall include all warrant articles submitted to it by an elected town officer. That's how the process starts. You have to submit it to the selectmen. The Board of Selectmen or City Council shall, within 14 days of receipt of such zoning ordinance or bylaw, submit it to the planning board for review. They did. Upon receipt, our clerk sent it to every member of the planning board. She did, for your review, prior to this hearing. And this hearing allows the review to take place. If this zoning bylaw came from some other party, it would happen in the same exact process. That process can't be flawed if that's how everyone is handled. If it was submitted by some other elected official that's not associated with the planning board, that's exactly what would happen. Submitted to the select board, 14 days to the planning board distributed for review. That's what the law says, that's what was done, it's legal and it's appropriate.
May I respond to that, Mr. Chairman?
Okay, I don't wanna get into too much of an argument, so
Okay.
last, I mean, there,
Thank you. And I think this is, again, a very important element. This is a hearing. The hearing is supposed to take information from individual citizens such as myself. And as a matter of fact, this goes to the crux of the situation that Mr. Robinson has not recused himself from the board, when he should have. The fact is now this has become a review, which is not the intention of a hearing. And as a result of that, I think that this hearing has, and is deviating from the protocols of a normal hearing. Because it is now becoming a review process, which is not, again, what the intention of this hearing is.
I understand.
I'll remind you.
Last word, and then we do need to deliberate at some point on this, so we need to end the public.
I'll remind you that this
Comment period.
is not just a hearing. This is a planning board meeting. And we have a hearing, and then we should close the hearing. And then, having received this document several weeks ago, you can conduct a review and generate the report, or not generate the report, and proceed down that path.
Yeah, I think
towards the
that's
town
correct,
meeting.
and I think that our time is pretty limited before the annual town meeting. So I would like to, if it's acceptable to other people, and they don't want to feel like I've cut people off, but to close the public part of this hearing, which doesn't mean we're going into executive session. I just want to close it, so those among us can make a recommendation to the town meeting, which is what we're charged with doing under the statute. So if there are no objections, then we'll close the public section of this meeting. Any objection from the board?
No.
It's closing the hearing.
Closing the hearing.
I think that requires a motion and a second.
Okay,
Vote.
so do I hear a motion to
I'll make-
close the hearing?
I'll make a motion to close the hearing.
Do I hear a second?
Second.
Okay, all in favor?
Aye.
Aye.
All opposed?
All opposed?
I'm not opposed.
Abstain?
I'm not voting.
Okay, abstain?
Abstain.
Thank you.
Okay, so, in terms of a process, a deliberative process, I think everyone should have a chance to speak to, if you want the pros and cons, or if you have a strong feeling one way or the other. But in the end, it would be helpful to maybe, air the views that we're concerned tonight. So if I give everybody a couple of minutes to speak, and generally the person chairing the meeting, according to the conventions that I've operated under the past, is the last one to speak and vote. So, who wants to start?
You wanna go first?
No.
No? Bill, you wanna
I'll
go first? All right.
Um,
We'll allow back and forth too, but
excuse me?
we'll allow some back and forth.
Oh,
People
okay,
can
that's
question
fine.
you too.
Tom, I would appreciate it if, I kinda was blindsided when this came out. To see it, to me, it's I would feel better if we brought it to our meeting and discussed it before we went to a hearing. I've never done this part of the process, but I think that would be more appropriate, instead of just saying, now we're gonna have hearings, and we had our meeting, and while we were told at that, what previous meeting was, we're having a hearing on this. And I felt like the planning board didn't have a say in it at all. It was, you were putting it forward, and this is, and that kind of, I didn't really have a chance, I read it, yes, but I think it's more important as a board, we're supposed to work together and talk about this, and is the board backing this?
You have to have a hearing by law.
Correct, but
I
you
didn't
can't-
call the hearing.
But you can't talk about this, what article you're gonna put through before we even go into the process, we can't talk about that?
Sure.
Well, that's,
You've had it for,
but we never did that part of the process, Tom.
About 3 weeks.
Right,
4
but we
weeks.
never had an opportunity to discuss any of this, until tonight, the hearing. I don't think that was appropriate, that kinda bothered me, cause I felt that you were putting it through as the chairman, and this is what the planning board really wouldn't have an opinion. That's the first impression I got out of it. And with that being said, and that's because of the way everything portrayed out, and how we just got notified in an email. personally, I believe in checks and balances. I think it's a good thing to have. I don't like the fact that under what you read there, I don't think that's appropriate. I think we should change that. The associate member should be a town resident. I agree with that. But I still believe we should have the checks and balances that are in place now under our current bylaws, which can supersede Mass General laws. That's all I have to say.
Craig?
So, Tom, to Francois even admitting that he did nothing illegal, if I'm correct. So
Thanks.
So I have so I have no say on that. 'Cause, I mean, if you did it the way you did it's legal. I mean, it's legal. So it is what it is.
Right.
I wish you would have brought it forward a little differently out of the courtesy for the rest of us, but in the end, you didn't have to. So, that being said, I feel like I just honestly don't feel like that bylaw needs to be changed. I mean, everybody's pretty much said here that it's worked for the last 20 plus years, and if I understand that there was an issue with not voting for the recommended person at the last meeting or the last appointment process. But that being said, I mean, I don't think, for an analogy, I don't think the president should be just telling people who should be in Congress or just putting people in Congress to benefit their, agenda. And I'm not saying that's what, you're trying to do. I'm just, in general. So in that process, I just think we should leave the bylaw the way it is.
I was not at all happy with the process that the Board of Selectmen took, in my opinion, took out of our hands. So I believe that we should change this. My personal opinion of the Board of Selectmen, I'm gonna shut my mouth on. And I won't go any further on that.
I am chairing the meeting. I'll probably be the last to vote on it. I think I have some thoughts. I do think
Excuse
that.
me, Alice, Tom has
Oh,
no.
Do I
Tom,
get to vote?
are you,
He gets,
I don't know, you're the presenter. Do you see it as a conflict voting on the,
Well, I haven't heard any reason to recuse myself. It's an administrative function. There's no third party that benefits from my involvement. The town benefits from at least considering this, and that's what I'd like to have happen. So I don't consider myself necessary to recuse myself. And if not recused, even in the opinion of people in town, there's no obligation to recuse. If I'm not recused, then I should retain the right to vote.
you wanna speak to the article? I mean, you have already, so a
Well,
quick,
um,
you're the sponsor of the article, you're clearly in
yeah.
favor of it.
The concept that the article was in some way presented in an underhanded way is not appropriate. I've read the town charter. It's the same way it would be done by any elected official. In terms of notice to the board, I'm pretty sure you had it for 3 weeks. If you've read it and you had a question, you know my phone number. No one's ever called me and said, "What's this all about?" It's a very simple change. It's pretty straightforward, and I think it's effective. This concept of checks and balances is a false issue when you're an elected board. Our check and balances are provided by the voters. We are a directly elected board answerable to no other elected board. We have to keep our autonomy. Otherwise, we'll be pushed around and influenced, and that's inappropriate. everything that was done, the, appointment or the, selection of the, associate member by this board, the actions, with respect to the Board of Selectmen, was all done by vote. We didn't slide anything through, we didn't manipulate anything. We duly elected a associate member. It was a 3-2 vote. The other thing is, when a chairman of a committee gets so frustrated with the select board that he resigns, and I happen to be the guy who steps in behind him, I feel an absolute obligation to the town to work hard to correct a very unfortunate and just a real bad situation. We can't let that kind of a thing happen and go unaddressed. The town deserves its very best people. There should be no resignations and disgust between one board and another board. There should be no board lording something over someone, oh, we're the appointers. And I just don't think this should go unaddressed. To leave it muddy is a mistake. I strongly recommend we clarify it and adopt this warrant article.
All right.
Period.
Okay.
Thanks for the chance to talk.
I guess my view is I see the pros and cons on both sides of this a bit. I think that, the way I was appointed to fill a vacancy in the board, which is also prescribed by our bylaw, is you assembled the select board, you assembled the planning board, and you took a vote. And I think that would probably be a better way to fill this position, and I don't know why it couldn't be filled that way, but that's not what we have, okay? So, and I do agree with Tom, certainly that position ought to be a town resident. And it's not correctly written the way it is, where it says the following people have to be, and they tacked it on to that group of people versus the people above that, the appointments above that, which clearly are better filled by citizens. So I don't think we're dealing with, I do think we're dealing with a flawed process and a situation that could be made a lot worse, a lot better. And unfortunately with the ambiguities, it all played out very badly. And as I guess it was Oliver Wendell Holmes said, hard cases make bad law because you try to correct it. I guess my feeling is that I don't feel like the correct thing is to let the planning board alone with no supervision fill that really what is a 6th seat. Because one of the main reasons you have that person is not the vacancy or the illness, it's a conflict. And if you adopt what you say, then you have the board that has a member that's conflicted has a lot of influence on nominating somebody to fill that seat. And what you're trying to get is a very neutral voice in that seat, somebody that doesn't have, a stake in the game. And so I do think the select board should be involved in it, just like they were involved in appointing me. It was a 1-year term, and then I have to run. Maybe it should be an elected term, but I guess I come down on the side that I don't feel like eliminating the role of oversight of the select board is the right answer, because that position is as important as my position, as appointed position to fill a vacancy. It should be taken with the same, and I think it is checks and balances. I don't think the select board, I wasn't there through this process of how you got appointed, and I don't want to re-argue history. But anyway, those are my thoughts. So, having weighed in as a board, we do have to take a vote on to recommend, and the review can include our reasons. I think we could also just report recommend or not recommend and the vote to the people. So, to some extent, and Christina can put together just a comment of when we held the meeting and the, you know, just a very straight what happened. And I don't think you need to summarize all of the arguments that are made here. So, I don't know whether people are prepared to vote or you want to deliberate at another time. The meeting is right coming up. So, if you, anybody else wanna make comments? I don't really wanna open up the meeting again.
No, I was just gonna say, if you're gonna take a vote, could I request that it be a roll call vote?
Well, it will be. I mean, I can do that, sure, but I don't know whether we're ready to vote. I don't know how people feel about it, and of course you can abstain as well, but
I'm ready to vote.
you wanna make a motion to terminate the,
I'm ready to vote.
discussion and vote?
Tom,
Proceed to
you ready
voting?
to vote?
I make a motion, we
Proceed to vote,
proceed to vote.
second,
Second.
all in favor?
Aye.
Everybody ready to vote? Okay, so the motion is to, I guess we'll make the we need to make the motion. You wanna make the motion? You gotta make it one way or the other, to
I'll make a
approve it?
motion to not support this bylaw change.
Okay, so the vote is to not support it. All right, so we'll proceed by voting with Tom? Yes?
Sorry, I need a second.
What?
The motion was
Oh,
just made.
second?
Second.
Second? You ready to vote?
I am.
Okay, Tom?
I'm in favor of the motion, so I think I should vote no against against the motion of not supporting it.
Right,
I vote no against not supporting it.
okay, Bill?
I vote for the motion.
Greg?
Vote for a motion.
I vote for the motion. Any further discussion? Any other? The agenda was limited to this one issue, so I'll entertain a motion to adjourn.
I'll second that.
Can I ask a question?
Generally, adjourning motions aren't debatable, but I'll let you.
So how does this pertain to being on the warrant?
Okay, that's a fair question.
Thank you.
So, it is on the warrant. It is not up to us, the five of us, to make this decision. It is on the warrant. The warrant always carries a recommendation, a planning board, a zoning board amendment. Well, every warrant article carries a recommendation from select board, and every zoning board warrant article also carries a recommendation from the planning board. So I understand, and Christina can correct me if I'm wrong, the select board has voted against the article, advised against the article?
They wrote on the article not recommended by
Not
the select
recommended.
board.
Okay, and so it will also go in as not recommended by the planning board, but it is totally up to the town, and people can speak at the town meeting on this article.
Right.
So it's
Thank you.
not our decision to make.
Yep.
Does that answer it?
Yes, it does.
Okay, we had a motion to adjourn,
It was seconded by Ken.
and we had a second. All in favor?
Aye.
Aye.
Tom, did you vote to adjourn? Or did you abstain?
I'll vote. to
Okay, I
adjourn.
just wanted to make sure. Thank you.